Thank you, Madam Chair. So the committee may recall from the hearing that Senate Bill 285 deals with state governmental ethics law. There are a couple of things the bill does with respect to first reimbursement for expenses. So under current law, legislators can accept reimbursement for actual expenses for travel and other expenses for attending meetings, programs, activities that are sponsored by, and there's a little list on page 3 of the bill that includes any national, nonprofit, nonpartisan organization established for the purpose of serving, informing, educating, and strengthening state legislators in all states of the nation. So you'll see that national is stricken, and also the purpose that the organization has to be established for is stricken, and it's just under the bill it would be any nonprofit, nonpartisan organization that does not engage in lobbying in the state of Kansas. So a legislature could accept reimbursement for expenses for attending meetings or activities associated with meetings or events with such that would be reimbursement would be provided by such an organization. Second thing the bill does is Section 2, it pertains just to governor, lieutenant governor, governor's spouse, and officers and employees of the executive branch, but also members of boards, commission, and authorities of the executive branch. And the second section of the bill pertains to when one of those persons can accept free or special discount tickets or access to entertainment or sporting events. So currently, one of those individuals cannot accept free or discounted entertainment access when the free or special discount tickets or access are provided because of the person's official position. So this bill strikes that and provides similar language to subsection D, which you see just above that portion, and provides an exception to the prohibition, one under A, line 33, if it's obvious to the person accepting the discount or free access that it's not being provided because of such person's official position, or two, if the person's presence at the event or activity serves a legitimate state purpose or interest, and the agency of the person's agency would authorizes or would authorize payment. So those two exceptions to the general rule that you cannot accept free or discounted entertainment or activities, and it follows the similar provisions that are laid out in subsection D just above it with respect to travel expenses. So that is what this bill does.
Thank you, Charles. I think we had a good conversation on this the other day, and I'm not aware of any amendments. Any comments? All right. I do have an amendment myself where we would take the contents of Senate Bill 285 and insert them into House Bill 2060. So we can continue to have this discussion with the House. I did look at 2060. It did not have a hearing in the House, so any of the information in the bill is not being deleted. So it's truly an empty shell. So we're not undoing someone's work. So I would make the motion to put Senate Bill 85 into House Bill 2060. Oh, yes, Charles.
Thank you, Madam Chair. Just a question. So as you know, there are two versions for Senate Bill 2060. One is House Bill 2060, and the other is substitute for House Bill 2060. And just for clarification, for preparing this, I'm wondering which bill you're referencing.
I knew 2060, so I'm looking at the supplemental note for substitute for House Bill 2060. Is there one better choice than the other that we're not? Is this the true empty shell? The Senate substitute is what I believe. Yes. So my amendment would be to insert the context of 2085 into substitute for House Bill 2060. That make it more clear. Senator Reichman seconds. All right, no discussion. All right, let's vote. All those in favor say aye. Opposed, no. Motion passes. Jill, do we have that all contained? This is proper. And then we need to send it out. So, okay. So would I have a motion to send out substitute for House Bill 2060, favorable for passage? Oh, you can have that motion, a second, as amended, yes, as amended as a substitute bill. So, Senator Petty.
Madam Chair, I'll make a motion to pass out substitute for House Bill 2060 as amended, favorably for passage.
Second, Senator Bowser. I'm sorry. Any questions? All in favor, say aye. Aye. Opposed, no. Motion passes.
And the committee's intent is that this be a substitute bill, is that correct?
Yes. And that is what the revisor would suggest, correct, Charles? Yes. So, committee, we had to move fast there. We have a informational hearing, so we did pass out the contents of Senate Bill 285 into House Substitute Bill 2060 for an update. Anything? All right, we have an informational hearing on Senate Bill 124. It's imposing unilateral annexation restrictions on cities and expanding the cause of action for landowners to challenge such annexations. And we do have a briefing from Charles.
Do you mind if I just stay here?
Oh, you stay right there, that's fine.
Thank you, Madam Chair. So Senate Bill 124 deals with annexation by cities. Under current law, written consent is required of the owner for a city to annex unplatted tract devoted to agricultural use that's greater than or equal to 21 acres. And one of the things this bill does is changes that on the first page, lines 29 through 32, to provide that written consent would be required for any tract of land that is less than 20 acres, in addition to any unplanted tract of land devoted to agricultural use. So the provision regarding 21 acres or more is stricken, and that requirement for written consent is expanded. On page 2 of the bill, the other thing this bill does pertains to narrow corridors of land, and there's currently a restriction in the law that you can see on page 2, lines 25 through 28, pertaining to that a city can't annex a narrow corridor of land to gain access to non-contiguous tracts of land, and there's a provision that it has to have a tangible value and purpose other than for enhancing future annexations if the city would annex it. And then that is changed, removes that condition, and then in addition, it provides that for purposes of ownership of land by a governmental entity, it accepts land owned by a federal or state agency or any other governmental agency or instrumentality thereof, except by the city. So land owned by another governmental entity would not be considered contiguous to the boundary of such city for purposes of any annexation. Finally, the bill creates a cause of action in Section 2. That's at the bottom of page 2. So there's currently a cause of action for an owner for the current exceptions in law, which are 1 through 6, and you can see those on the first page under Section 1. where a landowner can currently challenge an annexation, and the bill would specify in addition that any annexation of a narrow corridor of land prohibited under 15520G, which is that first section, the provision we just discussed, can be challenged by a landowner. And that is what the bill does.
Thank you, Charles. Any questions for Charles? All right. Well, let's call up our first proponent, Senator Doug Shane. Thank you for joining us. And as we've discussed, it's informational hearing, so we won't be having a vote on this bill this year, but we'll have it alive for next year. And after what we learned today, take it up consideration to put it up for one of the first bills that we hear. So, and are you missing a committee hearing right now that you'd like us to ask you questions afterwards so you can go on with your day?
Unfortunately, I'm not missing a committee hearing right now, so I'm
Oh,
free to hang around.
perfect. Well, what if we have you speak first, Senator Doug, and then we'll go to the other proponents, and then we'll ask questions, since you're not in a hurry to leave?
Sounds great.
Okay. Well, thank you. Well, welcome to the committee, Senator Doug Shane.
All right. Thank you, Madam Chair. Good to meet some of you on the committee for the first time. I'm glad Senator Titus and Senator Clifford came running back to hear me talk, so thank you for that. And thank you very much, committee, for having this informational hearing on Senate Bill 124. This is a really important issue, particularly for my Senate District 37, which is in a rapidly growing area of our state, particularly in southwest Johnson County, where there's a bit of concern and some ongoing battles really between the interests of rural property owners and cities, which also simultaneously need to be able to expand and grow to take on new population growth and economic development. The intent of this bill partly is to drive a conversation, and that's certainly something that I'm really looking forward to, and I do think an informational hearing is appropriate so that we can continue conversations with the League of Municipalities and with our counties to try to arrive at resolution to some of the important issues that are addressed by this bill. The other proponent conferee, Ms. Jennifer Williams, is going to be getting into some legal cases that have been happening and some research and history that she's been delving into related to this issue. But to give you an example of some of the things that we want to try to address, some specific examples. Not in my Senate district, but in my home county of Miami County, very recently, the city of Osawatomie decided that it was going to annex just directly up around 169 Highway in order to annex in a car dealership that was up the highway from the city of Osawatomie to try to capture the sales tax revenue from that particular car dealership that had been around for decades and not been within any of the municipal city limits, literally just going up the highway and having no other vested interest in annexation other than going up the highway to grab that car dealership. It was a very questionable practice and something that caused a lot of frustration and concern in our communities. We also know that in southwestern Johnson County, we've had recent examples, and Ms. Williams is going to be speaking to this, about the intentional acquisition of land to try to get a narrow corridor to connect two non-contiguous pieces of land for the purpose of annexation, and that was in an effort really to avoid island annexation hearings and other methods, other annexation practices. So the purpose of this bill is to not take away a municipality's ability to annex and a municipality's ability to grow, but to say this is a really challenging topic area with a lot of different interests. How do we make sure that we preserve the interests both of the city but also of the rural property owners that can be impacted by annexation? So that's really the spirit of the bill. I look forward to working with the League and with other folks to making sure that we arrive at a bill that makes mutual sense. And with that, I will go ahead and turn it over to Ms. Williams.
Thank you, Senator Shane. We have Jennifer Williams, President, Protect Rural JOCO. Is that how you say that, JOCO? Oh, wonderful. Well, welcome to the committee, Jennifer.
West corner of Miami County. So this particular situation we're dealing with affects about a 20 square mile area of unincorporated. And so I thank you for the opportunity to hear this. For the last 4+ years, the unincorporated neighbors have really been fighting to protect what we say are our God-given rights from man-made laws. We have these laws on the books, and we find that instead of the neighboring cities representing the interest of unincorporated, they claim they have to represent their best interest. And I won't read my testimony, but there's some questionable quotes from some city council members that should make anyone concerned on how they put their interest above the unincorporated. And so as they've come across this path and they've come into our area, the biggest problem we have is because the way home rule sets up, I say these kind of kingdoms for the cities once they take over, even the county no longer has a say. So our only source of representation from the county now has been stripped from us as well. And so we're left with a city wanting to surround us with an intermodal development in the middle of our rural residential neighborhood that was forbidden in the Southwest Area Plan that did a study of the area ahead of time to decide what was the best place for the growth, which was north and west of the highway, keep it out of the watershed. And then also, through this process, we found that they did whatever they could do to not have to buy at the commercial rates for the land that was developing organically around it, and they leapfrogged 1.5 to 2 miles over and found that connecting path. And in that process, we would have had a county hearing. We would have had the opportunity on an island annexation to come forward because it was out of the growth area still. But by getting cut out of that process and using the narrow corridor, they're claiming it's unilateral and that we really have no say. There was no hearing. They immediately went forward and annexed, and then the next day, before their non-contiguous land that would now become contiguous with this narrow corridor that was subdivided off of a 40-acre property just to get them across, and we have maps in here we can talk about further if there's time. In getting across to that, buying the property and jumping over, the very next day they did rezoning for 700 acres for land that wouldn't go into the city for 6 more days. So the intent was clear. The narrow corridor was to access that. And so as we look at the changes to G, the biggest reason for the change to G in the way that we've proposed it, it's not to stop narrow corridor if there's some reason other than connecting to non-contiguous. But the problem we have right now in the lawsuit of the state of Kansas versus the city of Edgerton for this specific violation is this case is coming before the judge in June, and the state tried to get this summary judgment in our favor, but the judge said the second sentence does not say that if a purpose was to enhance future annexations, that the annexation is unlawful, only that the city must demonstrate some tangible value and purpose other than to justify future annexations. So the city claims it has a tax value. Under that, every narrow corridor would have a value other than, and so it would really negate the entire purpose of that first sentence. And so if there is some language to clarify that first sentence, he'd also said it doesn't state that the primary purpose. And so to me, it's pretty clear you can't do this. If you need to do it for another reason, you can other than this, but he's saying if you can find another reason, then now suddenly one is negated and okay. And it's a really dangerous decision, I believe, that's getting ready to come to us here in June on what way that goes and how that is heard. And so I feel that the legislative intent is being undermined with the new interpretation, putting all of us in danger. The second problem with this and why we've changed 12-538, we urged this is also testimony in the packet, we urged the Attorney General Derek Schmidt at the time to help us with this narrow corridor, and we were told we had to hire our own attorney, that it was a private matter, which we did. And there's the transcript from the court case. The first judge said, I can see the illegality, but you don't have standing. So tens of thousands of dollars of legal fees. And finally, then we had an election. Chris Kobach was elected. He filed the case in 2023 to protect us, because one thing that the Judge Vano had said during that first lawsuit where Protect Rural Joco was the plaintiff was that this needs to be looked at further. The state needs to look at this. And so we have a situation here where the judge was he said, I'm put in a position here because how do I grant standing when 12-538 stops at 6? It's not real clear, it's ambiguous, yet we would have had standing if we had not had circumvented that island annexation. And so then we're leaving it to police between the two people that violated the law in hopes that nothing gets political and that the Attorney General has the time, the resources, and the ability to jump on board and help. And I just don't think property owners should ever be put in a position to have their property rights violated by questionable actions by cities when we should have the protection. And in every situation, it all comes back to the statute every time they put it back in your lap. And so that's why we are really just urging for any kind of help here. Citizens should not have to fight as hard as we've fought the last 4 years just to protect our home from what was decided in 2019 by Johnson County as incompatible development for the intermodal. Yet we have Edgerton was finally able to find their way to sneak through and suddenly changed it. And then they don't owe allegiance to us, they claim, because we can't vote for their city council, we can't serve on their city council, we are not a part of their city, yet they've basically invaded our home, which is about 7 miles away from their downtown. They put in a park to buffer themselves from the intermodal so they didn't have to deal with it, and then they jumped the highway using what I believe possibly was some KDOT land to get across that highway before more of the infiltration, I call it, occurred into our rural neighborhoods and watershed. And so a lot of the other information is in here, but I know for sake of time, if there's any other questions, we can discuss that. Or I've got maps in here as well that show.
Well, thank you, Jennifer. We'll hop to our next proponent and then have questions for you, all right?
Absolutely, thank you.
Nice job. Our next proponent, Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties. Welcome to the committee, Jay.
Thank you, Madam Chair, members of the committee. I am Jay Hall, the Deputy Director, General Counsel for the Kansas Association of Counties. I'm not going to talk about any specifics because I'm looking at this more on the holistic statewide basis. I'm not really looking at any specific issue. And this bill, Senate Bill 124, does actually two things. The first one, which we've heard a little about already, deals with the strip annexation where you take small portions of land to get to a portion of land that is not necessarily contiguous, and you kind of link together these strips to get to that portion of land. So that's kind of the second part of the bill. The first part of the bill deals with the categories under which you actually can do unilateral annexation. And one of the things that we look at, because obviously there are different ways that cities can expand, and I put in my testimony kind of the boxes you have to check when you're trying to do that unilateral annexation. One of the things that a lot of county residents, those that live in unincorporated areas, often have concerns about is that they feel that there should be some sort of representation from the county in this process. And right now there is no county step within that process. And so that may be something that as a committee that you consider when you are looking at this bill in the future, if it does move forward. So that's the basis of my testimony, is just giving you some ideas of things to look at, whether that be things that require notice or require specific county action within the bill for unilateral annexation to move forward. With that, I'd be happy to answer any questions. Again, I'm not going to talk about any specific cases, but I'd be happy to answer any questions that you might have.
Well, thank you, Jay. And you are the end of our proponents. Might not want to go too far in case we have any questions for you. Do we have questions, committee, for any of the three proponents? Senator Petty.
So I had a question for Jay. Jay, I'm looking at your testimony, and you were saying this bill does not address mutual annexation.
No, it does not. Yeah, no.
So when you talk about mutual annexation, you mean what?
When I talk about mutual annexation, that's where the landowner actually asks the city to annex their property into the city. And if the city decides to, then both parties have agreed, and that would be a mutual annexation.
And then the second one, it deals only with the unilateral annexation. So that's then when the city is just using these criterias.
That's correct. When the city is using the criteria laid out in 12-520.
And then the last point you added was there's no county step in the process of annexation.
Right. There's nothing that a city has to get any sort of permission or anything like that from the county. They obviously provide some notice, and there's some hearing steps along the way, but there's no permission or anything like that. And sometimes county residents wonder, why isn't there any sort of county involvement? Because I live in the county, I don't live in the city. Why is there no county involvement in this process? So just some things that I've heard from different constituents that may be of interest to this committee as you look at this legislation.
Thank you.
Senator Clifford.
Thank you, Madam Chair. Following Mr. Hall, I have a question for Senator Shane, if you don't mind. So does the 3 mile zone impact this as well?
In some cases, yes, because the city can have a plan that incorporates that, or doesn't incorporate, but utilizes that 3 mile zone, but they don't have to use that entire 3 mile span. So it could also impact that, but it doesn't have to. So they're two separate issues, but they can have some interplay with each other.
Thank you, Mr. Hall. And Madam Chair, for Senator Shane.
Senator Shane.
Was the implication that, I know there was an access corridor piece of this, but was the implication that they were literally appropriating a sales tax source into their city? Thank you, Senator Shane.
The simple answer is yes.
And what impact, I assume, a rural county may count on a car dealer for quite a proportion of their sales tax revenue. Do you know approximately the impact, or your legal counsel know?
I'm not sure what the specific fiscal impact was for the city of Osawatomie, but that car dealer as a kind of small rural and commuter car dealership. I mean, I think they sell about 300 cars a month out of that car dealership.
We have some expertise on the committee about car dealerships, so I thank you very much, Senator Shane. Thank you, Madam Chair.
Your car dealer friend would say $300, 300 cars a month. That is not a small dealer. So, do you have any questions over here? Jay, I have a question for you. This has a really familiar ring to it, a Senate Bill 37 that we've asked to have an interim study on. Does it fall under this category? Would this is something we could be discussing at the same time? And that is the 3 mile zone, isn't it? 37?
Yeah, so as I told Senator Clifford, those two issues can have some crossover, so it would certainly probably be prudent to have that discussion within that, because there is a lot of crossover between the 3 mile zone and some of the annexations that take place. But they are two separate issues in that you don't have to be using that 3 mile extraterritorial jurisdiction in order to annex the property. So they're two separate issues, but they do interact with each other.
Okay, that's helpful. Senator Bowser. Oh, go ahead. I'm sorry,
I was going to
Jay.
also respond to Senator Clifford's question about the sales tax. So if you capture that, the city would collect sales tax, but if the county had a sales tax, they would still be able to collect that sales tax as well. So essentially, it would just increase the amount of sales tax that is coming from that particular property. So if the city had a 1% tax and the county had a 1% tax, now you're collecting 2% from that property instead of just 1%. That would be the only difference there.
Senator Bowser. Oh, that's wonderful. There is actually a spot we mark on our sales tax receipt when we print those as a car dealer, is are you in city or not? So I follow that exactly. All right, I don't see any other questions. Thank you, Jennifer, for joining us. We don't have any questions for you, but we do appreciate you sticking around with us, and Senator Shane too. We do have written proponents: Brad Cupper, private citizen; Dennis Cook, private citizen; and Frank Bannister, private citizen. So we'll move into the opponents. We've done really well on time this morning. Our first opponent, Dan Warner, Planning Division Director, City of Topeka. Welcome to the committee, Dan.
Thank you, Senator Bowers. Thank you, committee, for entertaining some testimony this morning. I want to make a point first before I get into mine. counties have a process in the annexation statutes. It's island annexation. So there's an island annexation, unilateral, and consented. So first off, there's an overall concern about the pattern of legislative bills this session that are attempting to erode cities' ability to plan for growth by restricting their jurisdiction over the 3 Mile area and also now limiting annexation. Specific points about this bill: large platted commercial or industrial properties that are adjacent to the city, and they might be taking advantage of city services. So for instance, they might be on city water and sewer, cannot be unilaterally annexed under this bill if they were less than 20 acres. Line 29, the bill says that any land owned by a governmental agency shall not be considered contiguous to the boundary of a city for the purpose of annexation, even if it actually is contiguous to the boundary. That is contrary to the process in KSA 12523, which is this part of the statute that's being amended by this bill. That allows cities to annex governmental properties. So being unable to consider a governmental property as contiguous to the city's boundary could be a hindrance to city growth. Final point here, the sum total of the changes proposed in this bill undercut a city's ability to annex land to facilitate future growth. Cities need to grow in order to keep a city's economy moving forward. New growth helps pay for the infrastructure and services of the existing population, and a city that is unable to grow and add population will see its economy stagnate. Thank you.
Well, thank you, Dan. We'll move to our next opponent, so stick around, Dan, if we have some questions for you. John Goodyear, General Counsel, the League of Kansas Municipalities. Hello, John.
Thank you, Madam Chair. Members of the committee, good morning. My name is John Goodyear, and I'm General Counsel for the League of Kansas Municipalities. Grateful for the opportunity to weigh in this informational hearing and to assert what the city's position would be if the bill came forward in this form. Just as a starting point, the League supports the ability of local jurisdictions to make their own decisions regarding orderly growth through annexation. Senate Bill 124, as written, appears to prevent, if not all, most unilateral annexations. I don't know that, from listening to proponent testimony, I don't think that was the intent. So if there's a way that we can refine language to address their issues in a way that works better for cities, I would welcome the opportunity to work with the proponents and see if there's ways that we can do that. But as I read it, it effectively eliminates unilateral annexations because it outright prohibits the annexation of unplatted agricultural land and also prohibits unilateral annexation of any other tract of land that is less than 20 acres. The way I read it, that encapsulates all tracts of land because all tracts of land are either agricultural or not agricultural and less than 20 acres. I suppose there could be a non-agricultural tract of land that's 22 acres that we could annex, but I don't think that was the intent of that amendment there. The other thing I'll point out is that unilateral annexation is already limited in meaningful ways by current law. Cities can only utilize this process if one of those 6 criteria are met. It has to be land that adjoins the city. It has to be land owned by the city. It has to be land that lies within the city that has a common perimeter of more than 50%. So it's already limited quite a bit by state law. Additionally, once you get through that, once you determine that it is a piece of land that you can utilize in unilateral annexation, once we check one of those boxes, we still have to show a different number of things. We have to show that we can extend services to the area proposed to be annexed. There has to be a service extension plan. Following the preparation of that plan, the city has to determine the advisability of the annexation by a hearing. They give notice to people that are delineated in KSA 12-520A, which isn't in the bill, but the statute already says who has to get individualized notice. That includes the county, other governmental entities, and all affected property owners. When they're looking at advisability, they have to look at 16 different factors. This isn't something that we go into lightly. And I've listed those 16 factors. I will not read those to you. I've just, informational hearing, I wanted to provide some information there. So when is unilateral annexation most often used? It's most often used in a way to capture land that has been put into an enclave. Natural growth has created a pocket and cities already providing services within that pocket, but those property owners that are benefiting from being surrounded by the city are not contributing to the maintenance of city infrastructure, roads, utilities, by being part of the tax base. So that's the most common use, is to bring in those enclaves. Unilateral annexation is being used responsibly. It's limited by state law. Corridor annexations are already prohibited by state law unless given that certain, you can show that there's a tangible benefit other than annexation. If there's a way to rephrase that limitation, we would certainly welcome the ability to work with proponents and limit that, because outright, right now in the bill, it appears that the effect of deleting that second sentence is to outright prohibit corridor annexations. There are valid reasons for engaging in a corridor annexation. They're limited, granted, but there are valid reasons. So if there's ways that we could refine that language, we would welcome the opportunity to work with the proponents. Last thing I'll hit very quickly is that the new limitation proposed in new subsection H is at best unclear. It appears that if a city, even if county-owned property or state-owned property or federally owned property was within a city already, and it was on the outskirts, that a city couldn't consider that contiguous, despite the fact that it's already part of the city. So this would prohibit any city that has land owned by another governmental entity that happens to be on the outskirts of the city from growing. And I don't think that was the intent. And it does appear to contradict the prior section of law referenced in the prior conferee's testimony. So, Madam Chair, I'll stand for questions at the appropriate time. We would be, the League member cities would be opposed to this legislation as drafted, but we welcome opportunities to work with the proponents. I don't want to close that door ever.
Thank you, John. Since you're up there, we'll see. It's Senator Reichman has a question for you while you're standing.
Thank you very much, and thank you for your testimony. It seems like so often that the Deputy Director of Kansas Association of Counties and you guys are usually on the same side. And but I understand by this issue that you're not. Okay. Are you? I would guess, I'm pretty sure that this legislation is coming forward for what's happening in Egerton and what they was doing there. Are you familiar what is their case or their situation there?
My familiarity is very limited, Senator. So I can't speak directly to the circumstance.
Okay.
Speaking broadly to the practice of unilateral.
Sure, and I do appreciate the 16 things that you have that was on there. This is something that I didn't know anything about, and of course, trying to figure this thing out. And I understand that cities need to grow, but when you see something that looked like it's I got the power and going to do it, I think that's where, as a layman looking at that and say, that doesn't quite seem right. There should be a remedy or some way to figure this out. And when we are growing in population, we don't have that problem in Southwest Kansas. Okay, this is a situation we don't have. So it's nice that there is growing in there, but I really would like to see where there can be work out the differences, where something could be worked on this bill. And of course, it's in a court case anyway, and so it might not necessarily take care of their particular problem. But I do appreciate your testimony, and I'm just encouraging that both sides kind of work on something. I'm always concerned whenever we have a bill about a particular situation, okay? We want to fix that, but I want to make sure it doesn't mess up other parts of the state. It seems like so often we have that situation in local government, okay? And because they want to remedy whatever it is, and sometimes it's not our position to do that. Saying that, I am concerned about this, and I hope something can work out. So that was mainly a comment and encouragement for both sides to get together. Thank you. If you want to comment, that's fine.
Thank you, Senator. And after hearing all the testimony, I think there are ways that we can work together to address some of their issues and preserve. Anytime we look at a bill like this, there's competing rights at risk. So if we can work in a way that recognizes the rights of both sides, that's always the best way to go about this. In particular, the issue in Section 2 regarding standing. And I don't speak for my members at this point because I haven't heard from members on this, but that makes sense, I think. That seems like that's because the corridor part of the annexation statute came later, that might have just been an oversight at the time, that didn't get standing. It makes sense that if there's a prohibition in law, that there be standing to challenge based upon it. So that makes some sense, obviously. But again, welcome the opportunity to work. We may not be able to reach agreement on everything, but I think there's ways that we can tighten this up and address some of their issues.
Senator Clifford? Oh, yes, anyone can
Thank you.
up there now.
Thank you, Madam Chair. Thank you, Ms. Goodyear. I'm going to ask Ms. Williams to come back up to the podium, or Senator Shane could answer as well. We've heard from Mr. Goodyear about all the guardrails in place, but yet you bring a case where a judge seemingly has disregarded this, and the city obviously acted fairly hastily. What's your opinion of the guardrails that are in place, and how did this situation arise despite those guardrails? Thank you.
So based off of what he just said, I do agree that we can reach an agreement on Section G. Unfortunately, because of the way it's written, again, it's very clear, and the guardrails are there, I believe. It says you can't do this, period. Now, if there's another reason you need to do it for something else, okay. But for whatever reason, that's not the way it's being interpreted, and so if there's a different word that needs to be added or something, because I do agree, there are some reasons sometimes that you may need an narrow corridor for something completely different that's not for the very next day to go on to rezone 700 acres that was an island annexation that would have given people rights. And so, again, it is, to Mr. Eichmann's, I don't believe we're changing anything for a specific circumstance. I think a specific circumstance is taking a different direction than legislative intent, and there's just maybe one word could clear that up, possibly.
Thank you. Thank you, Madam Chair.
Thank you. I think what I heard, which was very important, is some representation from the county people with the city. And we've heard that in other comments through our session yet too. So I was very encouraged to hear that. Jay, maybe you had said that. Yeah, I think we're hearing that more often. It's a common theme that we should concentrate on that as well. Any other comments or questions? And then, John, did you mention the county had 3 points, you had something in the beginning of your testimony about the county 3, or maybe Jay had said that. You said it very well if you did. or perhaps Dan said that. Yeah, good. So sorry, Dan, can you say those again? I'd like to write those down because you're very clear on what you said. It made sense.
I was just pointing out, because there was a comment about the county possibly getting inserted into this unilateral process, that counties are part of the annexation process with island annexations. So state statute spells out island annexation process that includes the county. This unilateral does not. The process that's outlined in a separate section, those annexations do not have to go to the county, and neither do consents. So the point being that the counties are part of the island annexation process.
Okay. All right. That makes sense. Well, thank you for clearing that up for me. Any other comments? All right. Well, it's very encouraging that you all can hear each other's points and then work together over the summer before we come back, and maybe you'll have amendments to this bill that clarifies, and it could be just as easy as clarifying a word or two in statute that gets you closer to where we need to be. Well, I don't see any other questions. Thank you for joining us, everyone. And this will be our last meeting. So, I know, that is sad, isn't it? So, I am wondering, Randy, if we leave our folders here with you, we'll have Pages deliver our folders, so we'll give our Pages something to do. So, well, thank you, everyone, and we'll be seeing you on the floor with some